Hello and welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan, and today we'll delve into a significant Supreme Court judgment that clarifies the distinctions between a gift deed and a will, and how these instruments affect property rights. Understanding gift deed and will. A gift deed is a legal document where a person voluntarily transfers ownership of property to another without any monetary consideration. Key features include: must be executed voluntarily, requires acceptance by the recipient, must be registered under the Registration Act. Once executed and registered, it is irrevocable. A will is a legal declaration of a person's intentions regarding the distribution of their property after death. Key features include: takes effect only after the death of the testator, can be altered or revoked during the testator's lifetime, does not require registration, but it is advisable. Part 2, Case Background, NP Saseendran vs. NP Ponnamma. This dispute revolves around the interpretation of a document executed in 1985 by a father in favor of his daughter, NP Ponnamma. The question was whether this document was a gift deed, which takes effect immediately, or a will, which comes into force only after death. The property involved was residential. The father allegedly executed the document intending to transfer the property to Ponnamma. After his death, the son, NP Saseendran, challenged this transfer, claiming the document was in fact a will, not a gift deed, and therefore, he too had a share in the property as a legal heir. Part 3, Earlier Court Judgments. 1. Trial Court. The trial court accepted Saseendran's argument, treating the 1985 document as a will and not a gift deed. It observed that since the document was not acted upon during the lifetime of the father and possession did not change, the intention of the testator was to gift the property after his death. 2. First Appellate Court, District Court. The District Court upheld the trial court's findings. It concluded that the absence of immediate possession and continued occupation of the property by the father until death supported the interpretation of the document as a will. 3. High Court, Kerala High Court. In a surprising turn, the High Court reversed the lower court's findings. It ruled in favor of Ponnamma, holding the document to be a valid gift deed. The High Court observed that the use of words like gift and absolute transfer indicated a present and irrevocable intention to transfer ownership. Part 4, Issues before the Supreme Court. 1. Whether the document dated 1985 is a gift deed or a will. 2. Whether the transfer was immediate and irrevocable or testamentary in nature. 3. Whether delivery of possession is essential to determine the nature of the document. Part 5, Arguments by Parties. Appellant, Saseendran, argued that possession did not pass to the daughter during the father's lifetime. Claimed the document was not registered as a gift deed and hence should be treated as a will. Respondent, Ponnamma, highlighted that the language of the document clearly expressed an intent to gift. Argued that the requirement of possession transfer is not mandatory for a gift to be valid under Section 122 of the Transfer of Property Act. Part 6, Supreme Court Observations. The Supreme Court bench, comprising Justice B.R. Gavai and Justice Sandeep Mehta, delivered the judgment on 24 March 2025. Court observed: a gift deed must reflect the intention to divest the property immediately, and the 1985 document clearly used such language. The mere fact that the father continued to reside in the house did not negate the validity of the gift, especially if there was no express clause of revocation. The absence of registration alone could not nullify the transaction if all other conditions under the Transfer of Property Act were met and the parties treated the document as a gift deed. The High Court rightly interpreted the document and restored the daughter's ownership rights. Part 7, Final Judgment. The Supreme Court dismissed the appeal by Saseendran and affirmed the Kerala High Court's decision. It upheld the document as a valid gift deed, legally transferring the property to Ponnamma during the father's lifetime. Court decision is in favor of NP Ponnamma, the daughter, as it recognizes the 1985 document as a valid gift and upholds the transfer of property rights to her. The Supreme Court's above judgment in NP Saseendran vs. NP Ponnamma, decided on 24 March 2025, is reportable and can be considered a landmark judgment because it clearly demarcates the legal difference between a gift deed and a will, which is often misunderstood in property disputes. It reaffirms key principles regarding intention, delivery of possession, and legal effect of gift deeds under Section 122 of the Transfer of Property Act, 1882. It overturns concurrent findings of lower courts, making it a precedent-worthy clarification by the Supreme Court. Conclusion. This judgment emphasizes the importance of clarity in legal documents, irrevocable intent in gifting. The distinction between gift and will, especially regarding timing and effect of ownership transfer. This is a reportable and landmark judgment by the Honorable Supreme Court of India, as it resolves long-standing ambiguities between a gift deed and a will, especially in cases involving family property transfers. This decision will serve as a vital precedent for future legal interpretations and litigation involving property rights. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.